Okay, good morning. And today I am joined by Mr. Jon Sharp, all the way from sunny Scotland. How are you, John?
I'm well, thank you, Julie. Thank you. Yes, I'm all good.
Excellent. Now, I believe that you've recently qualified as an accredited civil and commercial mediator.
I have indeed. Yes, I can now call myself an accredited civil and commercial mediator.
Well, firstly, congratulations.
Thank you very much.
Okay. Secondly, can you explain the background regarding the use of civil or mediation rather in civil proceedings?
Yes, I can. When I first started practicing the law back in 1986, it was a very adversarial process. There was little formal scope for mediation. The only real alternative was arbitration, and that too was fairly adversarial and certainly didn't save any money in terms of costs. And what used to happen then is that lawyers ran litigation. The court was very much, can you seal this order, etc. And you made applications to the court only when you wanted to force the other side to do something. So for exchange of documents, etc. And lawyers scrapped. There is no other way to describe it. Lawyers fought hard. There was very little quarter given. And certainly in the Royal Courts of Justice in what's called the Bear Garden, when I first started to practice, it was packed with people making applications before the masters, etc. So it was very adversarial. Yes, of course, there was without prejudice discussions, but there was no formal process. And until in the late 1990s, the government appointed Lord Justice Wolfe to review civil procedure in this country. And he made two important changes. First, he effectively took away the power that lawyers then had to run cases. Instead, it was the court that now ran cases. So the court fixed timetables. The court takes control of the litigation. It's gone from being the lawyers running it and effectively using the court as a service to the court saying those days have gone. I'm afraid now you do what we tell you. He also said that there was an overriding objective that parties should cooperate to get the issues before the court there. So stop taking effectively small points, get on with it, cooperate, get the issues before the court. But he went further than that and introduced the concept of mediation. It's not a new concept, but it certainly now was given the court's blessing from about 1999. Because what he said, what he was concerned about, and it ran rightly, was 2 or 3 days of the court's time being taken up on a hearing involving either a very small amount of money or on a maybe 2 technical points. And really, if the parties had got together, it may well have been possible to settle it, which would have 2 advantages. It frees up the court's time so they can concentrate on more important cases. And it also saves the parties costs if they can mediate and settle their issues before going to a full-blooded trial.
Yeah.
So that he introduced that, and he also thought, well, what am I going to do here? Because I'm not sure lawyers will want to recommend mediation to their clients. So what he did was that he put basically a cost sanction. He said that basically, if you unreasonably refuse to take part in what's called, the general word for it is ADR, so it doesn't necessarily have to be a mediation. It can be an informal meeting or whatever. But if you just say, I'm not going, we're not doing it, no, then you run the risk that if you are successful in the case, you will not get all your costs back because you refused an offer of mediation.
Okay. So what is the position now regarding mediation? Will we see more mediation?
I think so. Well, gradually over the years, it has become, firstly, more popular. And with the introduction of pre-action protocols, there's often a mediation part to that. the courts have increasingly made it very clear that if you are offered mediation and you refuse it, cost sanctions will be imposed. Now, it has to be an unreasonable refusal, but that increasingly over the years has basically meant any form of refusal is not going to be looked on kindly by the court. So let me give you an example. There was a dilapidations case a little while ago, and the landlord was claiming, I think, £600,000 for dilapidations. The tenant made a without prejudice offer of £500,000, which the landlord rejected, but said, however, I'm happy to go to mediation. Now, when it came to the trial, the landlord actually didn't recover more than the £500,000 originally offered by the tenant. Now, that would normally mean that the landlord was stuck with the tenant's costs, etc. But the landlord successfully argued that having offered mediation, and the tenant didn't say anything about it, didn't say yes, didn't say no, he just did nothing, then the tenant was unable to recover the majority of his costs.
Right.
And increasingly, the courts are saying, sorry, there was an offer of mediation, you refused it with no good reason, sorry, you're not getting all of your costs back. Right. And there's been other provisions put in the White Book now, which means that basically the courts really do want you to go to mediate. Now, because of COVID and the backlog that has occurred in the court process, I think it's the Master of the Rolls has recently said that he is fully endorsing a mediation and alternative dispute resolution now.
Yeah.
He has said very clearly that within the next 2 years, it's going to be more or less compulsory to mediate. You won't be able to take matters further unless you can demonstrate to the court that you've at least had a go at mediation. You may not have been successful, don't get me wrong, it's not saying you've got to settle, but what it's saying is you've got to at least try to settle before you bring your case before the court. Right. And so I think in the next 2 years, it's very likely that mediation will become more or less compulsory.
Okay.
So as a result of that, there is likely to be a significant increase in mediation work.
Okay, understood. So how does a mediation work?
Well, all mediators have to go on a course which is approved by the Civil Mediation Council. And that basically teaches mediators how to effectively mediate in a formal mediation. But shortly what happens is this, the parties, one party will offer the other one a mediation, the other one will, if they've got any sense, will say, yes, okay. And then you look around for a mediator who is going to actually sit and do this mediation. Now, obviously, you want to have a mediator that knows something about the subject matter of your particular case. There's no point in getting a family lawyer, who's got great experience with family work and is a mediator to try and settle an aviation case. That's not a good thing. Now, so what you want to try and do is get a mediator who's got, so if you were picking me, for example, then I know about insurance, I know reinsurance, I know about marine, I know about aviation, I know about CMR, I know about goods in transit, and I know about general commercial disputes, and I know about construction. So, I would be perfectly happy to do that, etc. And what you also then get from both parties, once they've agreed on a mediator, is what's called a position statement. So it just sets out, not in huge detail necessarily, but in some detail, what their case is, where the case is. So it's basically, if you like, it's a briefing note for the mediator.
Right.
The mediator goes away and reads these, and then you go to the mediation. Now, mediations normally last either half a day or a day, but they can last longer. There's no reason why you couldn't have a 2 or 3 day mediation if the case was sufficiently complicated. And the mediator's job is not to judge, certainly not to give advice, but to try and find common ground between the parties to try and facilitate a settlement. And you do that by effectively, because I'm old and I remember Dr. Henry Kissinger, you do it by some form of shuttle diplomacy, I think it's called. So you put both parties in separate rooms and you shuttle as a mediator between the two in the hope that at some stage one party will make an offer to the other party and you negotiate a settlement. Now, there's three important things to remember. It is all confidential. So if the matter doesn't settle and goes forward, nothing that's been said in the mediation could be used in the future conduct of the litigation.
Yeah.
Until you have any settlement has been put into writing, it's not binding on any of the parties.
Yeah.
Yeah. And the other thing you have to remember as well, and it has to be said, is costs. A cost of a mediation for a day. An average mediator is about £2,000 for a day. More if it goes on after 6 o'clock, because they normally charge a fee of about, I don't know, £2.50 an hour or something.
Yeah.
And that's split between the parties. So realistically, that is a very cheap way of settling a dispute.
Yeah.
Now, there are arguments to say, well, mediation isn't suitable for really complex cases or cases involving huge sums of money. Well, that isn't true because it can work. And even if you couldn't settle the claim in full, what you might be able to do, so say there's 8 points of difference between the parties, you might not settle them all, but you might be able to settle half of them.
Yeah.
Now, even if you just settle half of them, that will reduce the length of the trial from maybe 2 weeks to a week, so that parties save costs on that. Yeah?
Yeah.
And so it's a very good way of, and reasonably inexpensive way of settling disputes. There's just one other point as well, that a court is going to decide matters according to the law. And so if you're just a straightforward debt claim, the court will say, yes, you do owe the money, pay it is judgment plus interest. Yeah. Now, in a mediation, it may be that you can come to a slightly different arrangement. So it may be that, yes, one party accepts that he owes the debt, but for various reasons can't actually afford to pay it. But what he can afford to do is, if there is going to be an ongoing, continuing business relationship with the parties, is maybe over the next year give the goods that he supplies to the other party over a discount of 10%. And that 10% over the next year will effectively amount to the amount of money owed. Now, that's not something a court will do. So it gives you more flexibility in settling your dispute. You can agree whatever you want, but it will be something that the court would not normally even think about doing.
Right.
So that shortly is mediation in a nutshell. And obviously I'm a great fan of it, but I would say that, wouldn't I? But you know, if you've got a dispute which is one of those, and I'm more talking to practitioners now, which falls into the awkward part. So it's between, say, 20 and 50,000.
Yeah.
The costs soon start to outstrip the amount that the parties are fighting over. And a quick way that maybe you can get it resolved is to mediate, which is in both parties' interests. Now, I'm not saying mediation works all the time. I've been actively involved in about 12 or 15 during my career. I think 12 settled and 3 didn't. So it's not, there's no guarantee of success, but for a relatively modest outlay, you might resolve one of those tricky disputes relatively inexpensively. And often what happens after a mediation, even if it doesn't settle, is the parties then do negotiate through their solicitors and say, you know, we nearly got there, we're prepared to do this.
Yeah.
So I always think it's worth having a go. And there we are. So,
okay. So that is a brief walk through mediation.
Brief walk through mediation, Julie, yes.
Thank you very much.
You're very welcome.
As always, if you wish to contact Jon regarding any mediation issues or indeed to discuss a dispute that you're having, Jon is available on his email of jon.sharp, jon.sharp, @fletcherday.co.uk. please feel free to email him directly. He will be happy to assist, I'm sure. Okay, John, thank you very much for that. And we look forward to speaking to you again soon.
Thank you very much indeed, Julie. Always a pleasure. Take care.
Bye.
Bye.